first session, which is the procedure to be adopted in conducting inquiry by the board. So now what would be the general procedure to be adopted in inquiry, which is the place of safe custody, safe custody of child in conflict with law and child in need of care and protection. What about the detention or police remand of the juvenile by investigating officer for the purpose of investigation of the case? What about the procedure to be adopted in case of child in conflict with law on bail fails to appear in the inquiry before the JJ board? These are certain aspects which are we going to be dealt in our first session. Our first session will be taken up by Madam Sonia Kinra. Madam Sonia Kinra had completed Masters in Law from Punjab University, Chandigarh in the year 2000 and even practiced for 7 years in the Punjab and Haryana High Court. Later on, in the year 2004, she joined Punjab Judicial Services. After working on many posts, she was promoted to Superior Judicial Services in the year 2016. She also headed Special Court under POCSO Act. Apart from her judicial services, she is also working for the rights of the children who are victim and who are in conflict with law. She has even presented a paper at national level and has various publications at both national and international platforms to her repute. Moreover, she has completed courses from various universities and other corporates like University of London, Manav Rachna University, Ville, etc. Currently, she is performing the assignment of faculty member, Chandigarh Judicial Academy. I welcome Sonia Kinra, ma'am, and I request her to take up the next session, the first session, ma'am.
Good morning, everybody, and I welcome all of you. After COVID, this is the first in-person meet of our judicial officers as well as the other stakeholders of the JJ board. This is just an effort, as told by Justice Masih, to make a joint effort for dispensation of justice to the children who are in conflict with law, whatever the reason may be. I suppose that the concept of juvenile justice is not new to India. Even if we look to the ancient times, the child below the age of 5 years, he was not supposed to be punished. He was to be nursed and educated with love and affection. There was a theory that thereafter you start punishing a child, but it should be gradually decreased in the later part of childhood, and thereafter it should be turned to advice. And after 16 years of age, the child should be treated, maybe a boy or a girl, as friend of the parents. And I think we are now returning back to that theory again, because our society is becoming child-centered now. So as told by Honorable Justice Masih, that he is not a accused, he is a child who has been in conflict with law. This has to be kept in mind. And by keeping this thing, 16 principles have been laid down in the Act. It is presumption of innocence, for rehabilitation, for giving him a right to dignity, and other principles on the basis of which we have to work. Because implementation is by other stakeholders, and legislation is already there. Now, depending upon these principles, these are the facts which are to be kept in mind again. A person before you is a child who happens to be in conflict with law and not an accused. It is an inquiry and not a trial. So don't adopt adversarial process, including the setting place of inquiry and even the dress to be worn. Lastly, be a foster parent of a CCL. This is, I think, covers everything to be a foster parent to a CCL. I know our principal magistrates, they are performing multifarious duties. They are not only holding the board, but I would quote an example of the various actors. They perform different role in different assignment, and that too concurrently at the same time. So we have also to perform those roles. We have to adapt the things when we are holding the board, and thereafter back to our position when we are holding the court. So coming back to the Act now. In the Act of 2015, child is defined under two categories, broad two categories, that is the child in conflict with law and child who is in need of care and protection. Again, the child who is in need of care and protection is the victim of two kinds. First, who is the victim of the offense under the Act, and second, who is the victim of the society. That is the abandoned child, surrendered child, or an orphan. And this Act aims at to ensure that children do not come into conflict with law at first place, and then they do not come to the formal criminal justice. That system is different, which has been made for them, and thereafter for the protection of the children who are already in conflict with law and to prevent their recidivism also. So again, the aims of the juvenile justice system is based upon the right, principles of restorative justice, best interest of child, and prevention as a primary object. Now just touching the definition part, I'll not go through the entire definition but only the relevant portions as we are involving other stakeholders, that is the best interest of the child first. It means the basis for any decision taken regarding the child. It should be to ensure that there is fulfillment of basic rights and needs, identity, social well-being, physical, emotional, and intellectual development as well. So this is the best interest of child. And child, earlier the child was defined as, in the case of girl, below 16 years, and in the case of boy below 18 years, but now the age is gender neutral. For both of them, it is 18 years. And CCL is a person, child in conflict with the person that who has committed, alleged to have committed some offense, but is below 18 years of age. Then comes the child-friendly atmosphere. Child-friendly, it not only should denote from the court setup, but even the behavior we show towards the child. Whether we are asking him as an accusing or we are treating him as a child only. So our behavior should be like that. We are not talking to an accused, maybe of any kind he has been accused of, but to a child. Then the Act has defined the offenses it has divided the offences into three parts: heinous, serious, and petty. Heinous offences, which are having the minimum punishment of 7 years. Again, there is distinction between the children who have committed the heinous offence up to age of 16 years and the children who have committed the heinous offence and they are between 16 to 18 years. So the procedure aspect, the nature of the offence, how they have to be dealt, who has to conduct the inquiry or the trial differs with regard to the age. Then comes the petty offences, of which the punishment prescribed either in the IPC or in any other act is either below 3 years or is only with fine. Now the definition of serious offences has been amended, wide amendment in the year 2021. Earlier there was discrepancy in this definition and it has been covered. Now it is the minimum imprisonment for more than 3 years and not exceeding 7 years, then it is a serious offence. Or if maximum imprisonment for more than 7 years is prescribed but no minimum punishment has been prescribed, then it is a serious offence. Or minimum imprisonment, if has been prescribed, it is less than 7 years. So this is the category of serious offences. Then comes the classification of offences. Depending upon the gravity of the offence, if it is punishable more than 7 years, then it is cognizable and non-bailable. If it is 3 years and above, but not more than 7 years, then it is non-cognizable and non-bailable. And if it is less than 3 years or with fine only, then non-cognizable and bailable. Now some homes have been described who are for CCL and some are for child in need of care and protection. This is the observation home. Observation home, it is the temporary reception for care and rehabilitation of any CCL, but it is during the pendency of inquiry only and not thereafter. Then comes the special home, which is distinct from the observation home. It is when the CCL has been found to be CCL. He has been found to have committed the offence alleged against him. Then the special home. And then comes the place of safety. Place of safety, it has been recommended to be at least one in a state. So a person above the age of 18 years or CCL who is between the age group of 16 to 18 years and accused of heinous offence, then he has to be kept in the place of safety. Even thereafter, there is the differentiation that the children who have been found to be in conflict with law, they have to be kept separate from the children who are facing either trial or inquiry, but above the age of 16 to 18 years. Then come the children home. It is for child in need of care and protection. Then is the fit facility. It is the also for temporary reason. If you find that any CCL has to be sent for any specific purpose, maybe he is a drug addict, he has to be sent to the de-addiction center, it is a fit facility for him. Now, though these definitions have been there, but the confusion state of mind is there whenever the child is produced before us for the first time. So these observation home, special home, place of safety, they have been categorized on the basis of the age as well as the nature of the offense. And there I have come to the view that there are 6 categories of children. first category is the CCL up to the age of 18 years who is under inquiry of petty or serious offences, and CCL up to the age of 16 years who is under inquiry and accused of heinous offence. So this is the first category. This one is the first, petty and serious up to 18 years, pendency of inquiry, observation home. If it is heinous but up to 16 years, then pendency of inquiry, observation home. Then comes the third and fourth category. Again, petty and serious offences up to 18 years and heinous offences up to 16 years. Here the CCL has already been found to be in conflict with law, that is after conclusion of the inquiry. Then it is the special home. But there is the provision that if the behavior of that CCL or it is seen that it is not in the interest of the other children who are residing in the special home or even the CCL who has been sent, then it should be shifted to the place of safety. Next, fifth and sixth categories. This is the heinous CCL who has committed heinous offence and is between the age of 16 to 18 years. Pendency of inquiry is there, or he has been found to be in conflict with law, then he has to be sent to place of safety. However, sometimes the situation arises that the child is not apprehended at the appropriate stage. He is apprehended long after the offence is committed. So in that situation, this situation may arise, that is the serious or heinous, completed 18 years but not 21 years. So then during pendency of inquiry, he has to be kept in the place of safety. So these are the categories where the child, according to the age, according to the nature of offence and according to the stage, has to be sent. Now, there is no provision under the Act that if the child attains the age of 21 years, either during pendency or thereafter, and if it is thereafter, then he has been found to be committed offence of serious nature or the heinous nature by the board. Because for the CC there is, but not for the board. Then in my view, the procedure which has been there, that he has to be transferred to the jail, it should be adopted. And if anybody has a different opinion, he or she may come out. Nobody? Now coming to various types of reports. These first two reports pertain to the adoption or the child in need of care and protection. And then comes the individual care plan. This is very important part, individual care plan, which has to be made part of the dispositional orders passed by the board. And I have seen many of the judgments, but I have not found any single of them to be making part of the dispositional order, this individual care plan. So it must be included. Again, the principle of rehabilitation of the child is violated if we do not follow this. Now this individual care plan, which is defined under Rule 2(9), it is to be prepared by probation officer or CWO, child welfare officer or social worker on form number 7. So it is a comprehensive development plan only for a child based on age and gender specific needs and case history of the child prepared in consultation with the child in order to restore the self-esteem of the child. It is very much required for his rehabilitation, reintegration into the society back, which is the main object of the act. And these are the points which are not exhaustive, but they are to be mentioned therein. Then comes the medical examination report, which is the report of a child given by a duly licensed physician. Then comes social background report. It is again to be prepared by now CWPO. So report of a child containing the background of the CCL prepared by CWPO. Then comes SIR, which is to be prepared by the probation officer or CWO or social worker on form number 6. So 2 reports have to be prepared by CWO or probation officer or social worker. In the beginning, that is within 15 days, it has to be presented when the child is produced before the JJB board. That is the SIR, and on the basis of this report only, the major decisions like bail and many other things, even the preliminary assessment, they can be taken by the JJB. The proceedings get held up when these reports are not being filed in time. So again, this report contains the circumstances, the situation of the child, which is on the economic, his social, what was the atmosphere of the home, what was the relationship between the CCL and parents with other siblings, with his friends, with society, and so on. Even I have come across one case in which the SIR was filed, but it was held by the Supreme Court that SIR does not state, even the social worker or the probation officer did not make attempt to converse with the neighbors of the CCL. In that case, the CCL was found to be alleged to have committed the murder of just 3 or 4-year-old girl. And thereafter, 3 or 4 days, a ransom call was also made. But what the story was put up by the CCL was that girl who was residing nearby in another flat, she used to come, she was playing, he got irritated, he just pushed her, and she got strangulated with the wire of the charger. And thereafter, he got confused what to do, and he concealed the dead body. And when he heard other persons speaking that no ransom call is there, he made the ransom call even thereafter 2 or 3 days. So in that case, it was held that the SIR, though it is mentioning about the relationship, he was the son of some gazetted officer, he was having the good atmosphere at home, he was very obedient child in the school, he was having good relationship with his friends, but there was nothing mentioned about the statements of the neighbors. So it was found that the circumstances, we have to look into the circumstances also in which the murder has been committed. So such is the importance of each and every aspect of the SIR. Now coming to the functions of the board. This is to provide a translator. We can find that a child may be from any other state, he is not or she is not knowing the Hindi language or the language of the court or any other language which we are using. So we need a translator. Then the interpreter may be required in some special children, special educator, and they should be provided. Even it has been provided that the interpreter or the special educator must be paid the fee of not less than 1500 per day, and to the translator not exceeding rupees 100 per page. What other functions? The board can issue rehabilitation card in form number 14. Even the board can pass orders for readmission. In the case I was talking about, the other flat holders who were neighbors, they stopped talking to the parents of the child and they had to shift from that place. And even there are many examples that if the child is absent due to maybe the investigation pendency or he is in the observation home, he is shunted out from the school. So the orders can be passed by the board with regard to readmission or the continuation of the child in school where the child has been discontinued. Then to interact with boards or other districts to facilitate speedy inquiry and disposal of cases through due process of law. It includes sending a child for the purpose of an inquiry or rehabilitation to a board in another district or state. There are other provisions also which empower the board to transfer the case. I have found this provision little bit contrary to our system, how the case has to be transferred from one district to other or from one state to other. But I have found this provision very useful in the case, suppose at the initial stage, the SJPU comes to you and asks for the literal sense we call police remand. Maybe the offense has been committed somewhere else, he is being investigated at another place where he is residing. There is the case of Master Bholu. In that case, the child, the CCL was taken to some other place. Even there is a case of Arjun, Master Arjun. And now how to give the custody to the police in that case? The common, otherwise we think, we just come to the conclusion there is no word of police remand and we cannot give police remand to the CCL. But what about investigation part? Should we stop the investigation there? Whether the case should be shunted, it should be shut there only? We can't do this also. So we have to find out the ways. Now in such situation, you can transfer the CCL to any other observation home where that CCL is required for investigation or to be taken for any other purpose of investigation. And thereafter, he can be directed to provide police assistance, to the police during daytime. Maybe from 10 a.m. to 5 p.m. and thereafter he will be kept there again. He will be deemed to be in the custody of the police officer you have given. Thereafter, even a member of the board can be asked to accompany, to look into that there is no violation of any of the principles or the rights of the CCL. Even the parents of the children, CCL, they can accompany, the advocate of the CCL can accompany, and in these manner we can direct the CCL for assistance to the police in investigation. Then comes to inspect child care institutions, to maintain a suggestion box even at the place where the board is being conducted, to ensure smooth functionings of the children committees, to review the children's suggestion book at least once in a month, to ensure that the legal probation officer in the DCPU and the state or district legal aid service authority extends free legal services to a child. Again, this is a right of a child to get free legal aid. Then to deploy, if necessary, the services of student volunteers or NGO volunteers for paralegal and other tasks. Other tasks include everything. I have received many queries from many stations that the SIRs are not being filed in time, final reports are not being filed in time. This you have to make an effort. Everything is provided in the Act. Take up the matter with your learned session judges. Take up the matter with the DSP. I suppose in every district now there is the DSP of women and children welfare. You can take up the matter there and get them expedited. We are not helpless. Then, before coming to the procedure, the rules which prescribe the procedure how to conduct the inquiry, I must sensitize with regard to again the principle of right to privacy and confidentiality. Whenever the child is produced before you, give him a fictitious name. It should not be reflected either in the index part or in the Zimnis what is the actual particulars of the CCL. Even it should not be in the statement under section 313 or the dispositional order. And wherever in-camera proceedings are there, they must be mentioned in dispositional orders. Then comes the principle of non-stigmatizing semantics. Again, it means that we do not have to use the accusatory words like arrest, remand, charge sheet, trial, prosecution, inmate, punishment. They should be avoided. I'll press upon again that we have to change our role whenever we are in the board. Our mindset should be shifted to the other side. Now coming to the inquiry. According to section 14, when child is produced before board, it shall hold inquiry and may pass order as deemed under section 17 or 18. Under 17, if it is not found to be CCL or the grounds are unfounded, he can be discharged, or if there is petty offences, he can be dealt accordingly. In petty offences, it's just summary trial. By now you must have seen about the traffic summaries also. What is there? So it is a summary trial like that. And then there is the period prescribed for conclusion of this inquiry. Originally it is 4 months and extension can be of 2 months only. So in 6 months you have to complete the inquiry in any of the offences. And this extension has to be provided by your CGM. You have to seek this extension. It is not the deemed extension. And if in the petty offences it is not completed within 6 months, the proceedings have to be terminated there and then. But don't make it a precedent by lingering on the petty offences for more than 6 months and then closing the case. It is provided that because as per procedure it can be completed much before that. Even I will come to the case monitoring sheet that how you can manage the cases so that they should be completed within time frame. Now, thereafter the board shall take the steps that satisfy itself that the child has not been subjected to any ill treatment. That may be at the hands of the SJPU or any other stakeholder. Then proceedings shall be conducted in child-friendly atmosphere, the opportunity of being heard. So this is again the principle of right to natural justice. Now, you all know that the CGM has the power to review the pendency of the case in every 3 months. You have to furnish the reports. Even high-level committee is there consisting of executive chairperson of SLSA, Home Secretary, Secretary responsible for implementation of this act, and a representative either from a voluntary or NGO to be nominated by chairperson. And duration of pendency, nature of pendency, and even the reasons thereof can be asked by this high-level committee. Board shall, I have told you, it furnish the information to CGM on quarterly basis, even regarding the reasons why they are pending beyond the period. Then DMA, now this is the amendment that the district magistrate may call for any information from the board. Now, in order to manage your court work, this is the case monitoring sheet on form number 11. The time schedule for disposal of the case is to be fixed by the board on the first date of hearing itself. So frame the time as 6 months is the maximum time. Frame the time that what is the ending day of the inquiry should be, that is 6 months after when the child has been produced. And schedule date given in column number 2 of progress of inquiry shall be the outer limit. Now I'll show you the form as well. This is the case monitoring sheet. Now this is the progress of inquiry. That one as the progress of inquiry. Day 1, special background report by police. This is dated. Day 1, consideration of bail on that day. Day 2 means next date, age determination, SIR, then section 173 CRPC final report. Day 3, and like this, the day 11, that is the post-dispositional review. It means that it should be, dispositional order should be passed by the 10th date. So this is the monitoring sheet which is provided in the Act, and by keeping at the top of the file, you can monitor that whether you are going by schedule or not. And this is the quarterly report by Juvenile Justice Board which has to be furnished. It is prescribed on form number 12. Now there are some guidelines, but I'll skip these guidelines due to paucity of time. Only refer to the guidelines which are pertaining to you. That is guideline number, this is point 4. In case of petty and serious offences and where apprehension of the child is not necessary, in the interest of the child, the SJPU or CWPO shall forward the information regarding the nature of offence plus social background report in form number 1 to the board when apprehension is not necessary. And second, intimate the parents or guardians as to when the child is to be produced before the board. And when the apprehension is necessary, and he is apprehended, the police officer shall place the child under the charge of SJPU if it is apprehended by the police. And thereafter SJPU or CWPO shall intimate immediately to whom? Firstly to the parents or guardian about the apprehension, along with the address of the board and date, time, venue when they will produce the CCL before the board, so that the parents can come over there. Then the probation officer concerned, so that the SBR can be filed in time. Then CWO or caseworker, so that he or she can accompany the SJPU or CWPO while producing the child before the board. Then Other necessary guidelines under this rule pertaining to you are when the child is released in a case where apprehension of the child is not warranted. One of the questions was asked, one of the query was that if such CCL is produced in the court, whether the court can release him under this provision under Rule 8, Sub-Rule 7. But to my mind, this provision is before production of the CCL before the board. By the police, it has to be there. If bailable, then they will grant. If non-bailable, then the bail is the option with the board. Then comes the Rule 9, that is the production of CCL before the board. When the CCL is produced before you, what the board has to do? The board can send the child to the observation home, place of safety, fit facility, or a fit person, wherever it is deemed necessary to the board. But the institutionalism is the last resort, must take care of this also. And where the alleged CCL under section 83 of the provision that is found to be used by either the militant or by any adult, then that child, even if he has surrendered, may be transferred to the committee as a child in need of care and protection. And then both the board and the CWC work together. In Delhi, I have found that the CCL who is even the runaway or he is found to be in need of care and protection, he is sent to CWC also. If he is sent to the children court, then practically the problem comes that how to produce that CCL before the board. As the children homes, the authorities of the children home are not aware of these procedures. So these are some gray areas which we have to work upon. Then comes whenever the alleged CCL is produced, the board has to review what? The report containing the SBR and the circumstances of apprehending the child. Along with it, offense alleged to have been committed by the child. And thereafter, you can pass orders under section 17 and 18. And even can refer the CCL to the committee if he is found so. He can be released in the supervision or custody of fit person or probation officers through an order in form number 3, and to direct the child to be kept in child care institution in order in form number 4. However, the dates which have been provided to you in the case monitoring sheet, they should not be on 15 days. It is provided in the Rule 10, Sub-Rule 2 that the date to be notified must be between 15 days. Now, if after conclusion of the inquiry, the order needs to be passed, dispositional order by the board can only be passed under section 18. These are the various orders, 7 types of orders which are there, including the probation and community service, all other orders which you are aware of. However, all these dispositional orders as per Rule 11, Sub-Rule 3 must include individual care plan as we have seen in form number 7. The board may order the child to be kept in place of safety and in a manner considered by appropriate where it is satisfied it is not in the interest of either the CCL or other children. As we have seen in the previous slide. and where the board decides to release the child after advice or admonition, or after participation in group counseling, or orders him to perform community service, then as per Rule 11 Sub-Rule 5, necessary directions have to be issued to the DCPU for arranging such counseling and community service. Where CCL does not comply with the probation conditions, what option the board has? The board may order to produce the child and send the child to a special home or place of safety for the remaining period of supervision. But this period again should not exceed 3 years, because the 3 years is the maximum limit. Now, this eventuality, when will you come across this eventuality? Only when will you seek the reports even thereafter, even after passing of the dispositional orders. At the time of dispositional order, maybe your original file is consigned, but the individual care plan and the review of the report periodically should be fixed, and that should be numbered as CRM, and thereafter it should go as CRM and periodic review should be there. Even you can pass the order to release the CCL on execution of a personal bond without surety, fit facility or special home, but it should be located near to the residence of the parent. But however, this is not mandatory if you found that it is not in the best interest of the child. Again, section 97 is there for you. You can invoke this power to release a child from an institution. But the thing is that it will come only when you will keep the track of the CCL. If you don't have the track of the CCL, you cannot invoke this provision. You can release him with conditions, without conditions, under supervision, and this is one of the form of the rehabilitation. Even the leave of absence can be granted by you on special occasions like examination, marriage of relative, death of kith or kin, accident or serious illness of parent, or in any of the emergency. And during that period, however, it should not be exceeding 7 days at a stretch. But that period will be counted during his stay in the home. However, if you forfeit that order or you revoke that order and the CCL does not surrender, then that period has not to be included. That period will mean extension of the period beyond 3 years. Here again the provision that if inquiry, it is satisfied that CCL should be transferred to place of residence, he could be transferred, but after completion of the inquiry. The board has the power to transfer him after completion of inquiry and not prior to it. And if even it is found that within this state he should be transferred from any children home or special home, it can be ordered so also. Even the state then has to transfer the child. For some reason, it has to take the orders either from the board or the CWC as the situation is. Then during inquiry, you can dispense with the attendance of the child whenever you feel, and it is in the interest of the child and the proceedings can go even in his absence. Whenever a child is found to be suffering from a disease requiring prolonged medical treatment of physical or mental complaint that will respond to treatment, he can be sent to the fit facility. any child kept in a special home is found to be mentally ill or addicted, he can be ordered to be removed to a fit facility again, maybe a psychiatric hospital or the de-addiction center. Now, what if you pass the order and it requires some amendment? Whether you can review your order. Section 104 provides so that the order can be reviewed, but to what extent? It is with regard to the institution to which you have sent, or as to the person under whose care or supervision a child is to be placed under this act. And at least 2 members of the board, of which one shall be the principal magistrate, should be there. Even the clerical mistakes in orders passed by the committee or the boards, or errors arising from any accidental slip or omission, be corrected by the board. Now comes the very important thing, what should be the contents of the dispositional order? As I told you, you must assign fictitious identity. It should not name the CCL with his original name and particulars. Mentioning of facts along with reports containing complaint by CWPO, circumstances of apprehending the child. Now, what should be the points of determination? As in the criminal cases, this is the inquiry under the criminal, so you have to find out the points for determination. First, you have to make the point of the age. You will give your finding that he is below 18 years of age. Then, nature of offense and whether offense committed by the juvenile or not. And to reach the conclusion, what has to be taken care of? The report containing circumstances of apprehending, a social investigation report in Form 6, evidence produced by the parties, nature of offense, specific need for supervision or intervention, past conduct of the child, social background report and circumstances apprehending and alleged under which he has committed the offense, discussion, and that discussion should include the contrary view taken by, if any, by any of the members of the board. Then your findings. Order on rehabilitation and individual care plan in form number 7 be formed part of the dispositional order. Order regarding removal of disqualification must be there, as again this is a right of the child, and safe custody or destruction of the relevant record after the expiry of the period of appeal or reasonable period that cannot go beyond 7 years must be passed. It is with the direction to the police even and your registry. Order regarding not to reveal the identity of CCL. As per section 3, subsection 11, again you yourself have to take care and you have to pass order that the identity of the CCL should not be disclosed. Now, this was all about the how to conduct. Now, the question arises whether the board can invoke power under section 319 CRPC to summon the additional accused who is not juvenile. It is for the obvious reasons you cannot try juvenile along with the adult. And so, as per the wording of 319, that if the additional accused is found to have the sufficient evidences against him to try him along with the accused before you, can you summon that accused? The answer is in the case laws Raj Yadav versus alias Raju Mahato versus State of Jharkhand, Criminal Revision number 997 of 2014, decided on 5th of August 2015. it has relied upon the case of Raju versus State of Haryana, 2004 SCC Online P&H 717. And even thereafter, the larger bench was formed by our Honorable High Court, and again the question of law was the same. It was held that this power of the JJ board is incidental and ancillary to main power to take cognizance as part of normal process in the administration of criminal justice. The only prohibition is that it cannot charge or try a juvenile for an offense together with the person. But such prohibition does not bar JJB from taking cognizance and summoning a person against whom incriminating evidence comes during the trial. So you have the power, but once the accused is produced before you, you will order to separate the challan and present it before the appropriate court. And even thereafter, these were followed in another cases also. Now, many queries have been put, and one of them was also that in case principal magistrate has recorded the statement of witness under section 164 CRPC, then whether the board can try the case or refer the case to CGM for transferring the same. There is no bar in the CRPC that the magistrate who has recorded the statement cannot try the case. And more particularly, before the board when there is only one board in one district. However, the eventuality later on can arise that when any of the counsel, either for the prosecution or for the defense, they want to cross-examine that magistrate. Otherwise, there is no bar and you can try that case. The judgments are there that 164 CRPC statement is not necessary that it should be proved through magistrate only. But in that situation, we can tackle the situation by referring the matter to the Honorable High Court, because it will be inter-sea or interstate transfer. This was the answer to my mind. Our learned session judge will reply also and highlight the situations thereafter in his session also. Then, whether CCL can be directed to assist in investigation. I have taken this point during my session. Then whether the child is to be sent after 21 years of age if he attains the said age, said question has also been dealt with. And whether social background report on form number 1 can be in local language. I think it can be. The thing is only that it should be in detail. If any problem is coming in getting it typed in English, it can be in vernacular language. The actual facts must come before the board. That is necessary. Then at the time of production of juvenile, can Aadhaar card be considered for age proof if no other document is available? It cannot be. Aadhaar card is the self-declaratory document and it cannot be. So, any other questions now? Yes, officers? पीछे से किसी को कुछ पूछना हो? Thank you.
Thank you very much, ma'am, for such a detailed discussion, and I hope this will help our stakeholders in deciding such inquiries. Now, we shall be breaking for tea for 15 minutes, and